If that happens, then we're going to meet with the officer, trying to persuade them to dismiss the ALS case. And sometimes they're willing to do that. But if they're not willing to do that, the officer will present you with an ultimatum. And they'll say, on the one hand, I'll dismiss this driver's license issue if you promise to plead guilty to the DUI. Obviously not the best option in fighting the case. Or you can have an ALS hearing, where the officer has to testify under oath to the administrative judge. And the judge is considering whether, by a preponderance of the evidence, just more likely than not, a tilting of the scales, number one, that the officer had reasonable grounds to arrest for DUI, and two, either you agreed to chemical testing of your blood, breath, or urine under the implied consent warning and the results were 0.08 or more, or you had refused that testing. If the judge finds reasonable grounds to arrest and that you had submitted to the test and the results were 0.08 or greater, the judge will only impose a 30-day suspension of the license, and during that time you can actually get a limited driving permit. If you had refused that testing, the judge will impose a 12-month suspension of the license, and it's a hard suspension, meaning no limited permit is available.